Apa kabar? Semoga dalam keadaan sehat. I will open the session in Bahasa Indonesia and then I will switch. Semoga Mas dan Mbak semua dalam keadaan bahagia dan dalam keadaan sehat tentunya. Karena pada siang hari ini kita kedatangan tamu spesial, praktisi, kita sebutnya praktisi mengajar ya. Karena dari sisi praktisi, Pak Lukas adalah seorang lawyer yang sudah bekerja di Indonesia selama 8 tahun. Nanti kita akan dengarkan pemaparan dari Pak Lukas selama 45 menit ya, 45 menit. So don't worry. 45 menit lalu nanti kita akan tanya jawab. Harapannya adik-adik di sini nanti silahkan senyamannya saja apakah mau menggunakan bahasa Indonesia atau bahasa Inggris ketika tanya jawab ya. Tapi kalau misalnya dalam bahasa Inggris langsung itu akan memudahkan saya dan Bu Vika. Walaupun Pak Lukas di sini bisa bahasa Indonesia, ya Pak ya. Tuh, tapi sedikit. Jadi nanti bisa switch, tapi lebih nyamannya kalau Pak Lukas nanti dalam bahasa Inggris. Oke, tanpa berlama-lama mungkin saya akan langsung hand over to Pak Lukas. So Pak Lukas, you may introduce yourself as well as follow up by the presentations of your material. So over to you Pak Lukas.
Thank you very much. Use this one.
But if you want to move around, do you guys prefer Pak Lukas to move around or stay here? Move around, see.
I'll move around. No, it's better that I will move around, no worries. But just for the first for the non-interesting part, I will sit down, which is introducing me. So I'm Luca Mascarade. I'm a French lawyer. And I've been in Indonesia back and forth for 8 years. And I wanted for 8 years, and I'm so happy and so thankful and honored to be here with you today, because it's the first time I come to UBM, to this prestigious university. And so thank you so much, really, Alfatika, because it's terima kasih banyak. It's really an honor to be here and to discuss with you today. So it will be a session which is a professional session. So the objective and what we discussed about when we prepared this this session is for you, because you will not necessarily, but you might tomorrow, so very soon after you graduate and after you will be professional, to handle with people like me. So what I am. So I'm a lawyer. I'm a French lawyer, but prior to that, I'm French. So I'm advocate assis, and it is always interesting to try to understand in order to advise, in order to render your job the best you can, to apprehend, to understand the other person you have in front of you. And it's like, I'm talking about asking, but it will be the same with your Indonesian client. So you need to understand where they come from, what is their knowledge about law, what is their methodology of work, what is their objectives. And that's what we're trying to discuss today from my humble and little experience I had in Indonesia as a foreign lawyer. So maybe we can start. So of course, we will have a Q&A session after. I'll try to be short, but I'll try. Okay. Perfect. Yeah, and but for the slides, how can I? Maybe easier. Say next. Okay. Okay, next. So yes. So this objective. So there is this professional objective, which is more on a cultural sense. So on this, you will have to ask questions on these matters. But of course, it's about law. We are in a professional master, so we will tackle some some aspect and the methodology of drafting in, international agreements. So meaning not necessarily international agreement, because there can be agreements under where we are right now in France. We have so in Indonesia, you are lucky. You really are lucky compared to French notary, because it used to be the same, because that's the introduction and the main, especially. So I'm a French lawyer, so I'm from a civil law country. The civil code was a French elaboration. I'll come back to it later, but we share quite the same legal system. And at the origin, almost the same prerogatives, same work, same status. And it changed a little bit at the starting the 1960s, 1970s, where the role of a notary in France is really limited to private dealing. And so you have the chance as Indonesian notary to be exposed, to work on so many other matters, and especially company law, which is now in France, the French notary, they can work in company law, but very in specific matters which are really small compared to what you can do here. So that's really interesting. You have choose a great idea to be a notary in Indonesia. So we have two, because that's one of the specificity in France, but in Indonesia as well. But like to lesser extent, there's a real role of tax collection from the French notary, and they can. So some of the notary they are really specialized in taxation in pajak, but as well. So this specific, it will be for certain actors. They will.
Recording in progress.
They will. They will still legalize documents and so on. But it's true today, it's the two main roles of French notaries are real estate, is still, like here, and succession, succession. So yes, that's you have the chance as notary in Indonesia to really tackle a lot of subjects, and that's really interesting. But I will come back to this. So if you can go back to the presentation, so on the objectives. So the objective of but just because it's not really important what is written. So I mentioned it already. The first objective is to have a cultural exchange for you to anticipate the questions that your foreign clients may have, and in order to do so, I've tried to emphasize on the differences between our two systems, and again, the French system and the Indonesian system, we share a lot of things. So it's a good example. So of course I'm sure it's not gonna interest you only if we deal with French law, but take it as an example of what can be a European investor. So for the plan, there will be the business practices. in terms of environment. So I'm going to give you a bit of insight on EU and the legal systems. And we will tackle the cultural consideration, which are plenty. And then we will go in the substance, which is contractual technique in terms of methodology. And I will give you a few examples on which are emphasizing what we're trying to achieve here. Next. Okay. So why? So first, so again, I'm not here to talk about EU. I'm just giving an example, and it's an example that I know. Otherwise, I'm not. If I was doing it on the US, I would have no idea. So it's an example, and the why my first idea is to superpose so the map of Indonesia towards the EU map, which is not EU actually, but it's to give you an idea of the diversity. So that when I first arrived in Indonesia, so that's the first thing. If you have an European client, investor, or business partner, and so on, there's a lot of chances that he doesn't know at all about Indonesia. And to be honest, because I studied in Singapore, before coming to Jakarta, I had almost no idea. I had almost no idea and about the diversity of Indonesia. But in terms of size, we have the same in Europe. Because, so if you take, so it's London from almost Afghanistan, if you take this distance, in terms of legal system, you have all the legal system of the world which are included in the same distance. So thankfully in Indonesia, it's a unified one. It's not in Europe. Europe plus Turkey and include even the Middle East. So that's the first task, is to understand where the clients are coming from, even within the EU, because in the EU system, next for the slide, in the EU system, so you have like here, so I'm narrowing down to the EU, we have 27 member states with supranational institutions, with the European Commission, the Parliament, and the Council, which will be a bit, we have superseded democratic institutions that we had in most of the member states at the national level to the European level. But this system, there is a tendency and a trend to harmonize regulation in Europe, but still, and especially for you, future notaries, the matters that are interesting you, it's still national. So French law will be different from the Spanish law, from Italian law, from Irish law, and so on and so forth. So that's really important to know where the people are from, because in the dialogue you're gonna start with this client, it's important because you have specificities and to make yourself understood better. Next. So that's we can go next again. Voilà, so this I talked. So I already mentioned this supranational system. So I mentioned, so they have this, so we have this national on these matters, but we have also supranational law, which is the EU law, and we have two types. One which is directly applicable, and it's regulation. So the European Union through a democratic process and the Parliament pass laws like any country, democratic country, and it directly applies to the members. Okay, so to French and to, by extension, to their companies and citizens. And then we have the directives, which are regulation, which are not directly applicable, but they will have to go through the DPR of each country in order to be applicable. And there's a margin of interpretation. It depends on the text of the directive. And then we have supranational treaties, which have actually the same value as other international treaties. Next. So it's not it's a conclusion to the introduction. Again, it will not be automatic, but when you have a foreign counterpart, or if you are assisting, because this is something that you will necessarily do in your profession, and that we have. For instance, so you will work with a lawyer, Indonesian lawyer, but the counterpart is a foreign company or a foreign citizen. You might want to, in your advice, emphasize some matters depending on where this particular person is from. And why I took the example of the EU, it's also because we have the two legal systems. Like I mentioned earlier, in France, it's the civil code, which shares the same system with Indonesia. But within the EU, we have countries where it is a common law system. So, of course, or the UK, where prior they left the EU before the Brexit, but as well Ireland, which is still, but we have also Malta and Cyprus, which are based on common law. So the examples, and even if a lawyer, if a French, for instance, if a French company use a Singaporean lawyer to deal with their matters in Indonesia, it will not be the same methodology as if a French lawyer is advising a Canada company in Indonesia. So this is really important, and I'm trying to give you some sensibilization about this, because these two systems, and I will give you practical examples after, where we have some misunderstanding from these counterparts, which can lead to some issues. Next. So the cultural considerations. Again, here I'm trying more, so it's I open on the nationality, cultural difference, but it's always generalities. So of course, everything that I'm going to tell you about this, it's only based on my again humble experience, and it's always generalities. But there are some trends depending on the education system, about the experience system all over the world. But what I wanted to tell you here is as well the cultural difference. It will very depend on the function, on the position of the person you will have in front of you. So, and really you have to ask yourself, what are they? So is it the owner of the company? And to me, tell me if I'm wrong, but and again here it's more on the cultural aspect. So, but it will be the same in Indonesia. Who is your client? It's really important to understand who is your client, or who is the client of the person you're working with, because if he's the owner of a company, a CEO, if he has a finance background, if he is a business developer, if he is an in-house legal counsel, if he is a lawyer, and especially if he's a foreign lawyer, our perceptions will be different. What we tell to them will be apprehended, understood by them differently. So, for instance, if you take a CEO and a CEO or corporate officer, and to be honest, in my practice, most of the time I am at the beginning of the relationship, of the investment in Indonesia. So they are coming to, I'm going to take the example of a French company. The French company is coming to Indonesia. They know the potential of Indonesia. If they come, they want to be here, but they don't understand how. So they are checking the opportunities, they are meeting with potential business partners, they are meeting with institutions, with BKPM, so they can explain to them how they can invest in Indonesia. But themselves, most of the time, they don't have legal knowledge. So they have, and especially in France, they have quite a huge in-house legal team. They are not really into that amount of detail. So it's important to clarify at the maximum what you're going to tell them. So that's the first. So for the business developers, it's even worse because they really have no clues of law and how is it to legally structure an activity or an investment or a commercial agreement in Indonesia. In-house legal counsel, you will think it will be better. And it is, because we are talking the same language, we have basically the same training, so we understand each other. But here you have to adapt between the origin of this in-house counsel. If he's from Singapore, watch out. It's not against Singaporean. I have nothing against Singaporean lawyer, in-house counsel. I'm just or Malaysian, like any common law system, country, because maybe we will use the same terminology. So if you can like translate it, and if you're comfortable with talking in English, but the word, the concept behind the terminology might be different. So you might think you understand each other, but actually you don't. So that's complicated. And then if it's a French in-house legal counsel, you're not going to understand each other because of the accent. So it's going to be a bit complicated. And I'm sorry about that. It's really important to make this work at the beginning, because it will save you some time. It will give you like more insight on a competitive advantage actually. If you manage to make the regulation, how you're going to present the regulation and so on, the clearer it is, the better it is. And you can really create a trustful relationship with a client, and that's the aim. We are so notary is, in terms of ranking, I must say it's higher than lawyers, because lawyers we are but auxiliary of justice. But at the end of the day, we are all here to create a trustful relationship with our clients. So it's important to have it. Next. So, like I was saying, so here more in the technical, in the substantive detail. So as legal practitioners, we are all but tiny person on the shoulders of giants. This is something that was some professor, some docent told me when I was there at this university. So it's the University of Montpellier, which is one of the oldest university in Europe. And it's really, again, it has to accompany you throughout your career, because as legal practitioners, we exist only because hundreds of other legal practitioners before us have done the same job over and over. And why I'm showing you this is also to present myself. So I'm from Montpellier in the south of France, and there is in Montpellier, so next, a methodology which was applied. So that's why it's the title of my presentation today. It's technique contractuelle, so contractual technique, which was made by Professor Jean-Marc Mousseron, and it was designed, this methodology, to assist enterprises, companies, from their creation to their liquidation, but also in the contractual agreement, drafting, negotiation, and so on. can do next for the slide. And this, so because the Montpellier have said it, and why we share a common heritage as well in Indonesia and in France, the civil code was firstly drafted in France, has been brought through history, even though by the Dutch, but the essence of the civil code was drafted in France with several principles. And several principles which are, to me, very applicable as well in Indonesia. That is still applicable at the European level today, but also in other countries like in Indonesia. And the first one is the harmonization, the previsibility, the security of the legal rule in a legal system. So, and why I'm mentioning this in terms of in my presentation and Montpellier, because the person who designed, who was in charge, who was managing the project made by Napoleon to draft the civil code is a gentleman called Cambaceres, who was from my hometown and from this university. So it's really important that we have more and more exchange about this. Concerning the civil code and the contractual part of it, because of course we have differences in other areas of the private law. So this methodology, it is based on the life of an agreement, and so from the beginning to the end, and to have like sample clauses that you can adapt and that you will use and analyze depending on the various situations. Next. So of course, if you're dealing with a foreign client, so here it's more, I know it's a bit out of the scope of a notary expertise, because here for the drafting, the negotiation, it will be more the job of a lawyer, but still, and you know, I guess, actually it's a question, do you deal in your practice as notary, do you deal with contract which are not under Indonesian law? Yeah? Mm. Mm. Of course, yeah, definitely. So here you have indeed to check on this, and so well, for the choice of law, this will be, but you know it. I'm sure you have courses, and I'm not going to spend a long time on this, but it's important as if you need to advise at one point. Well, it's true based on my practice. I usually recommend when you have a French supplier to apply Indonesian law. So sometimes it's mandatory. I will talk about it later, but because if you want, because at the end, what's the most important is that the agreement that the parties reach is enforceable. So if it's not, so what? Next. So for the contractual techniques, next. So yes, again, here I'm going to try, because I'm already a bit too long, but the preliminary agreement is an important part, because, for instance, in France, we have a dedicated jurisprudence, so case law basis concerning preliminary agreements, which is kind of it's an exception from the general rule of the civil code. So in terms of enforceability, so all the clauses, they will be enforceable, but on the substantial agreement, part of the agreement, we will recognize that it is not necessarily applicable if the conditions set in the preliminary agreement, so in the LOI or the MOU, are not met, which is not really the case in Indonesia. So same here, so again, everything that I'm going to give you from now on, it's what is for me the most obvious differences between the two systems, And that here you say, okay, so there's this part, maybe I will emphasize it in the communication with the client or the lawyer who is representing the foreign party. Because here, yes, when we draft agreement today, and with my colleagues, so Indonesian lawyer colleagues, we emphasize on the non-binding nature of the MOU or LOI, because otherwise, if all the conditions are set to make an agreement, it will be totally enforceable. It is, and it's so that's the thing, because if, for instance, in France, if you draft the agreement with substance clause, and it has all the conditions to be a material substantive agreement, but if you just call it LOI or MOU at the beginning as a title, and you put in preamble that it's just a basis of the negotiation, it will not apply. It will not be enforceable, except, of course, if you have included exclusivity in the negotiation, except if you have included a confidentiality obligation, and so on and so forth. So that's why it's really important, because we had some cases here where we had to enforce. Next. So for the execution of the agreement, so for the first part, for the substantive conditions, again, we share a lot of things. Why I've just highlighted in terms of consent capacity object and lawful cause is that it's just that in France, we have abandoned this notion of cause, which is a bit, it's like this. It was too, actually, it's a mark of harmonization with European law for some part. Others will say because it was too much, it was complexifying too much agreements. But on this, I'm not enough knowledgeable about Indonesian law to have further comments on this part. For the formal conditions, from my perspective, what I was like a bit shocked when I arrived was the mandatory use of the Indonesian language, because it was not, I totally understand why it's used, but it was on the legal basis that I was a bit confused, because to me it didn't necessarily require a dedicated law or regulation, because it was already covered by the consent. If someone is signing a contract where you don't understand the language, there's no consent. So I was a bit surprised to have this law and the confusion it was causing. So now with the Supreme Court circular resolution, it's way more. It has been clarified, but from 2009 to 2023, it was a lot of years where it's vague and confused. So, but we are still, for instance, in practice, the Indonesian lawyer, they always recommend to have. Still use the translation, because the jurisprudence is not super clear on that yet. So just in case, yeah, for litigation and even for consent like this, we want to be sure that the other party understand, and as well. So that's another thing which is important, and especially, and it works as well for notary. Because as notary, sometimes you can do actor you can draft and notarize actor, which are in English. You cannot include the translation in actor. Yeah, you can. So, and be sure that the foreigner understand English. Because if he doesn't, that's same. And it's not, and I have the case where we have, that we haven't, so it's an agreement which is made in Indonesia and in French, so I'm happy. But one of the party is Chinese. So like, so there's one part, Indonesian, one part French, and a Chinese guy in the middle. The guy doesn't understand French, Indonesian, French. The, no, so yeah, no, we refused. Actually, it was proposed by the other party, and directly I said, no, we cannot sign this version because one of the party, Chinese national, cannot understand neither French, neither Indonesian. So we have to, we're changing to English. So, yeah.
But in case of dispute,
Yeah, that happens, and it's because it's a substantive condition of the formation of the agreement. So it's so important, and it happens quite often. So yeah, well, then I pass on the other, but it's true. So one of the other part, you have European clients, you're dealing with European companies. Like I told you in introduction, as Indonesian notary, you are lucky because your scope is bigger. But what does it mean? It means that all these companies, all these clients in Europe, for instance, at least in France, I'm just going to talk about France, they forgot that what was the job of the notary. And so they rediscover the job of an Indonesian notary. So every time we have to explain, it's like this anyway. For instance, it's for the legalization of foreign agreements and so on. And this, the foreign investors, they are always complaining about this. Now with the apostille, since 2 years, it really speeded up the process, so that's great. But this is something that has to be said in advance for them to anticipate. And again, what you can say is, because there's another example, another thing, because sometimes foreign investors are saying Indonesia is complicated administratively and so on. It's not true. It's not true. Try to buy an estate or an agricultural estate in France. It is more complicated. More complicated. So the thing is, it has to be clarified from the beginning, saying, okay, this might be simple for you, but we have these steps. There are some different steps in France, for instance, but so just to highlight it at the beginning of the discussion. So the process with the public notary, for instance, for the buying property, it's in front of a notary. It's quite straightforward, but so that's the principle. It's straightforward, but you have exceptions depending on the activity. So for instance, if you're buying, so I've assisted in an Indonesian client to acquire a winery production in Bordeaux. And so wine production, it's agriculture. And the same like here, of course, agriculture estate, it's specifically regulated. And you have no, it's so complicated. no, because you have almost 5 levels of agreements from so the local community, basically, from the regional government, from the government actually, but sectorial, from the Chamber of Agriculture, from the winery association, so it's yeah, but easy authorization. It's not license, but it's administrative authorization, like a permit. So plus the building, which has to be normal. It is so complicated. So yeah, it is. But for this particular, but yeah, of course, I'm saying. Yeah, that's true. But everything is balanced. You have matters where it's way more complicated in Indonesia and in France. Next. Yes, so another part where just to highlight, and here it's more on the likeliness between the specific agreements, where agency, distribution, and franchise. I will do the both at the same time. So well, this one is I take the example of the Indonesian regulation in order to again to emphasize on the differences and what to tell the foreign investor. Because in this one, and this I've talked as well with the Indonesian embassy in Paris, it's not applied. No one is respecting it, and the problem is not no one, but the rate. So also the funny thing is it's after the apostille, the number of distribution agreements registered to the Indonesian embassy has decreased by 90%. Because, for only one reason, because they thought that apostille was replacing the registration to the trade attaché of the Quai d'Ouvert. So, and it's not the case. There's still, for this type of agreement, so agency, distribution, franchise, they have to be registered at the commercial attaché. The commercial attaché actually has to offer it. And this is not being done, and the consequences are dire because it's a condition of validity of the agreement. So if, for instance, you see that an Indonesian lawyer, well, as a notary here, it's a bit more far, but if an Indonesian lawyer is advising a foreign company and the foreign company has not registered the agreement, really has to highlight it. It's really a default. So yeah. So next, same for the franchise. It's basically the same. And we have, I will just to give you in terms of, this is something we could talk at a different moment, but there's a lot of regulation protective to the franchise in Europe. Same for the distribution, especially in terms of non-performance and liabilities and consumer rights as well. But yeah, I will not come into too much detail at this point. Next. Voilà. Alors, this one was to make a little break in the presentation. So it's more on the theatrical part. So here I'm gonna move. I told you I will move. So I'm gonna move. It's almost a theatrical scene. I will do the French guy. I'm gonna try to be in this role. So why I'm taking this example? It's because it happens every not every year, every day. At least every day. So not necessarily with a French guy, but with a foreigner. They all want to buy a piece of land in Bali. Usually they have no idea about the country of origin law. And you have to explain something which is so complicated for them. And in this example, so I'm doing Pierre, so you can write, so I will do with an even worse French accent just for you. Hello, I am Pierre. I would like to buy a villa with a freehold in Kangoo. Is it possible? So of course, and here I'm taking the example of an agent, so not someone who is necessarily knowledgeable about law. Sure, but under Hackpacket and HGB, only if you incorporate a company with a minimum, blah, 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 blah. Bon. The first thing is on that, freehold. Is it an Indonesian law concept? For me, or here it's debatable, but as a civil lawyer, I don't understand what is the concept of freehold. Because for me, all property is freehold. For me, it's a common law legal system, a common law principle that for commercial reason, we have applied to real estate and to Indonesian law. Because the problem is after they're talking about leasehold. A leasehold, it's a lease. There's no lease. It's not hack milk, but it's not a hack as well. It's just a lease, an agreement between two parties concerning the use of a real estate. So it's here. That's why I'm a bit pissed about this matter, because you hear everything and it's contrary. So of course here it's a basic that you can read online and so on, but it might be false. It is false. And of course, after, the consequences are, because of the confusion there was at the beginning, people thought that they were actually owner of the place, and they actually don't. So it's really important. So if tomorrow, and this as notary, it might happen to you, you deal with property law and concept in Indonesia, will give you, so for the civil law country, a key to explain them. Next. So it's the dismemberment of ownership. So it's a big word for something which is actually quite similar with some tricks. So I guess this you have. I don't. Is this something which is part of the legal? So for the dismemberment, usus fructus and abusus. Is it something that you've already read? Maybe in history of law or something like that. Okay. Well, so when you explain, I know it's not the same, and I'm sure your professor will be mad at me, but it's just to give, again, to educate the foreign investor to what is Indonesian law. So, because if you started by talking about Hackpacket and HGB, it will necessarily be different from what he understands. But if you attach fructose to Hackpacket, even though if it's not exactly the same, the foreign investor will understand. Because in France, it's widely spread, and we use it a lot, especially in terms of inheritance. Because we have tax benefit when we do so. For instance, with my parents or my grandparents, I will become usufruitier, so usufructuary. When they pass away, the tax collection will be less. Well, anyway, so that's the kind of things you can say. Well, Hackpacket, you are almost, for a time period, of course, limited in time, you can be almost like an usufruitier, so usufructuary. Alors for HGB, it's a bit more complicated because in France, we don't have this concept. Because HGB, you have, either you have the bare owner, so the nu propriétaire, who has the abusus, or you have nothing. Or you have the usufruitier, so you have usus and fructus. So yes, it's really, and if you explain it like this, saying, okay, so Hackpacket, you are almost like the usufructuary for a limited time, and the Hackpacket is registered to the BTPN? BPN, to BPN. So you have a real title. Plus, if you have a company, you can do on the HGB, or maybe it's the opposite. But well, anyway, you have certain rights of the bear owner of the new propriétaire. It will be clear, and voilà, and he will be more confident and relax about his investment in Indonesia. Next. So the other part, and like I was saying in introduction, concerning the role of a notary. So this part, I discovered it when I arrived in Indonesia, because M&A, mergers and acquisition, in France, we almost never deal with notaries. Compared to here, where of course we have to, so all the shareholder resolution have to be notarized. You are, as a notary, almost like so that's the thing. This is something you can say as well, even if you are marketing yourself. You can say almost. So here it's even more when you're dealing with a common law people actually, but you are almost like a company secretary, because you are in charge of the compliance of the company with the company law. So your role is super important. And you have a lot. So in an acquisition process, with or without chain of control anyway, as notary, you have a lot of role, and you will be involved in this process. And this is something you might give a heads up to a client who is contemplating an acquisition. No need. No need. Yes. No, so we cannot be attached to a company. Cannot be attached, and so there's a numerous clauses for the notaries. So you have a certain amount of notary per local area. Per it's not the same thing in Indonesia. So yeah, we have the same. So it's so basically when you are a young notary, you have sufficient cash and you buy the shares of a notarial study, or you have to work as a notarial clerk for quite some times and to wait that the shareholder are transferring you the shares and so on. So it's quite it comes from actually the history of and I come back to Napoleon. So in the system, he had to create a new caste of notability in France, and the notary are part of it because they are delegated. So in France, as notary, you have a delegation of public service, which is on tax collection and which is on the authentication. So, but it's the same here. So voilà, that was just to give you this, to say you can advertise, you can market yourself as advisor throughout the relationship of an investment. So it's super important, and to say and to highlight it is to say, so it's not about the general compliance every year of the company law. It's also during an acquisition process, and you have to show your talents in this part. Yes. Next. So after for the non-performance, so more here it's more on the contractual technique. So in France, for instance, we have 5 remedies, whereas in Indonesia, I understand there are 3. So which is specific performance. So the obligation to perform as agreed. So it's linked to the nature, to the performance in nature. But we have also reduction in price, damages, of course, the termination, of course, and the withholding of performance. And all of this is governed by the good faith principle. which is the same as here. So on this, I'm sure you know about it. Next. That's in French. It's for me if I was forgetting the free principle. So next. So the dispute resolution. So you might be a bit less involved in this matter, but it's still really important. So for me, what was surprising is that the exclusion of the Article 1266 of the Indonesian Civil Code, which is a bit, I love it because it's a bit like more like if you were putting spell in an agreement, you know, it's like magical formula. You have to include it everywhere and all the time. The mediation part is very interesting. The fact that the mediation is required in all civil cases, which is really not the case in France. France is taking, so we've organized last month the first French-Indonesian dialogue about law. And we talked a lot about mediation and how, so we had the visit a delegation of French judge. And they were really interested. So this is really a topic where there will be cooperation between our two countries, because the mediation practice in Indonesia is way longer, more experienced than in France. So we will have a lot to talk about. It's a very important principle, interesting principle. And then, so for the Indonesia International, so I'm coming back for the international private law. This is really important. Indonesia is not part of the Hague Convention of 2019 on the recognition and enforcement of foreign judgment, which is something that the legal counsel should be very strict on this one, because if you conclude an agreement with a foreign party under a different law, different jurisdiction, and as Indonesia is not part of the convention, it will not be enforceable in Indonesia, the judgment of a foreign jurisdiction. So that's why in practice, for me, in the agreement, the Indonesian lawyer, they will always include either the Indonesian jurisdiction as a dispute resolution clause or arbitration, which is because Indonesia is part of the New York Convention, so you can enforce an arbitral award rendered overseas. However, to be honest, in practice, it's better to choose, for enforcement for exequatur purpose, it's better to choose an Indonesian arbitration center. I think I'm way over 45 minutes. I respect it because no. So the thing is, it was almost 1 hour and a half. But when I see it's better 45 minutes.
You may have a seat, Pak Lucas. Now we are in a Q&A session, and I believe there are many questions from the students, especially with regards to the international commercial contracts. I think the timekeeper is trying to respect you as the speaker. They don't want to cut you in the middle of the presentation. Oh, please. Now we are in the Q&A session. So if you have any questions or maybe comments, or maybe you want a confirmation as well, you are welcome to ask Pak Lucas a question. We also have Ibu Vika. Ibu Vika, I believe you already have question as well, but we will give the chance to the students first. Oke, ada yang mau tanya silahkan. Boleh dalam bahasa Indonesia, boleh dalam bahasa Inggris, dipersilahkan. Boleh. Siapa? Masnya tadi nggak angkat tangan? Ya. Tadi menarik sekali ya, apalagi untuk yang dispute resolutions, you mentioned that parties are free to choose. However, I have many experience actually with regards to French counterpart. They're very hard to negotiate, especially with regards to the choice of law and forum. They're very common.
No, I totally agree with you, and it's so stupid. Yeah, because it's because that's why we are doing this today. It's because they are not informed. I have many times and many discussions with general counsel in France say, oh, no, we want French law, law. But, okay, you have French law, but the decision of the French judge, you will never enforce it in Indonesia.
Yes.
So what's the point of having, and this is because they don't know about it. So it's our role as legal counsel to tell them, like, stop,
Yeah.
you're making a mistake.
Yeah.
And I totally agree with you.
Yes, because I've been representing UGM for the negotiation with the international counterpart, and one of the hardest negotiation is when I had this conversation with the French counterpart, regulating about the dispute settlement on the choice of law and choice of forum. The center of gravity of the contract is actually in Indonesia. It's about the joint research program. They're the funder in French. It's a French company, but the human resources, the researchers are Indonesian. The locus, the location of the research is in Indonesia. The object of the research are in Indonesia. So I'm trying so hard to, explain to them that in order to be able to be enforceable, I suggest you to use Indonesian law. And then they refuse it. So to strike a balance, at the end of the day, we choose Singapore International Arbitration Center with Indonesian law. Yes. And they agree on it. So, yeah.
And that's okay. And to me,
Yeah. And that's after 6 months of negotiation.
because at the end of the day, the worst thing is that it's for them.
Yes, correct.
And to be honest, when I'm representing, so here it would be, so because as a foreign lawyer, I don't do Indonesian law. So I'm just in the middle.
Yeah.
But I don't give opinion. I don't draft under Indonesian law. I can. But sometimes I represent Indonesian clients against French people, but under French law.
Okay.
Okay. But if I was an Indonesian lawyer, or if you draft, I represent an Indonesian counterpart.
Okay.
I will say when a French guy is telling me I want French law, I will say, yeah, of course, please.
Oh, please go ahead. But it is not enforceable.
It's not enforceable. So if he's sending stuff, so that's why it's, and at the end, it's almost the position I'm saying. The position in the negotiation is to say,
okay,
whatever you want.
So I'm gonna use your trick next time I negotiate with the French counterpart.
Yeah, you
it's
should.
very, very nice.
You're very good. I like this with nonchalance and like, okay, just do it.
Just do it, okay. And let's see. Alright, ada pertanyaan dari teman-teman?
I think we also have questions.
Gak kelihatan, Mbak. Saya minus, Mbak. Boleh dibacain?
Okay, I think this question is still in line with what you're discussing about the choice of law and also dispute resolution forum. The question that we get this in online is related with enforcing foreign arbitral awards in Indonesia, but I believe that we already have the arbitration law, so I think it's no doubt that it is enforceable. But is there by any chance you ever stumble on a case where you have an obstacles related with this case enforcing the foreign arbitral awards? Because it is true that it is enforceable, but probably related with the procedural stuff, probably you met some of the obstacles.
I see. Yeah, it's a good question, and again, here my answer will be only on the practical side. To be honest, no, it's going to be a lawyer answer. It depends. It depends on how the complementary clause was drafted, and it depends on the arbitrary on the seat. But lately, no issue. Lately, no issue. But in terms of strategies, that's it. It's what you mentioned. So it's to apply Indonesian law. So that's the thing, because normally for based on the New York Convention, it doesn't matter which law you are using. But it's true that, so that's to answer the question about strategy, apply Indonesian law. That's insane. Now that's what we include in all our agreements. It's Indonesian law. So So again, it depends. But if we have a European supplier sending supplies in Indonesia, for instance, we'll include the Indonesian law, and with an arbitration, maybe Bani, it's easier to enforce. But you go to LCC, you go to SIAC, it's okay as well.
The win-win solution, actually. Because when it goes, usually when it's been some time and it's been too long for negotiation, it is not good as well for the contract itself, because we cannot implement that before it is concluded, right? So what we do is we try to negotiate and try to choose third party forum as well as third party law. Sometimes we do not use Indonesian law or even French law, but we use Singaporean law. So just to make everything easier at the end of the day.
Yeah, but so on this, for me, I'm because why choosing a common law? Why not like so in certain sector, for instance, when we have this, we apply Swiss law because it's neutral. Switzerland, there's nothing more neutral in Switzerland. So like because Singapore, to me, so you have two parties who are civil law. I'm a bit
But have you been in a situation where the two parties didn't agree on the dispute settlement, especially on the forum and the price of law, and they choose to go silent in the country? I mean, it's like just a general, but it's not really self-explanatory, but that's against the purpose of the contract in the first place.
so I see it a lot of time, but it's because they have drafted the agreement without a legal concern, without a lawyer. Because no, we have to include it. So it's the basic.
So have you ever draft a contract where there are more than one choice of law? So for example, in one part, let's say on the substantive condition, you refer to a certain law, and then let's say for the other part on how to determine the damages, then you refer to another law.
Again, I've seen it, but I've never. I don't know what's your view
I
on
think
it.
the French terms would be defecage, but I don't know how to properly pronounce it.
No, I mean, I understand, but to me, it's a contract has to be.
Ambiguous.
Yeah, and yeah, sorry, I forgot. It's another quote that I love. That like an international agreement, it's not a straight jacket. You know, a straight jacket is something that you use in asylum. It's a vivid relationship among living parties, but it's the beginning of the relationship, a contract. So if you complexify the beginning of a relationship, what is it gonna be in 5-10 years? You see what I mean? So and I understand that in very complex agreements, and especially with public purchase, public order agreements, sometimes it can make sense depending on the specificities of a very particular industry. Okay, we can go to that, but for me, as a principle, the simpler, the better for this type of things. But again, I'm just a lawyer.
Yeah, we have one more question. Oh yeah.
Take questions from the students in here. This is your chance.
There's another question on the how can Indonesian practitioner address the lack of legal
Yeah.
agreement? But it's really you mentioned it. It's
With MOU.
yes, but it's just to emphasize the substance of the preliminary agreement. We say to condition every enforceability to this agreement.
I think for that to have an discussion in Indonesian context, we do recognize there's not lack of recognition, but we do recognize this preliminary agreement, such as MOU, LOI, and the other type of agreement, as long as it complies with Article 1320 of the validity of the contract, as long as it fulfills that, then it will be enforceable. Sometimes it is misleading in practice because the title is MOU or LOI, whereas the substance is actually already, right and obligation. Now the question, if that's the case, is it enforceable or not? complies with the T20, then it is a valid agreement and it is enforceable. So that's usually in the context of Indonesia, because we at UGM itself, if we look back in the context of UGM, we are more on the flexible side of the party, and we will follow what our partners suggest in terms of the, what is it called, like the terminology of the agreement. So we are okay. Sometimes I also found that the title is Memorandum of Understanding, but actually the substance or the substantive of the agreement is Memorandum of Agreement. There are obligations, there are rights, and even there are financial obligations. Tanyanya masalah
Sedangkan kalau di Singapura itu, kalau misalkan ada putusan pengadilan yang tidak dilaksanakan dengan baik, maka ada apa ya, katakanlah semacam ancaman gitu. Apakah itu yang menyebabkan kalau misalkan ada masalah antara mau pakai hukum mana, makanya menggunakan hukum Singapura seperti itu, Bu? Ihsan, Bu. Nggih.
Thank you pertanyaannya. Saya nggak bisa menjawab pertanyaannya karena saya bukan ahli hukum Singapura gitu. Tapi mungkin Mas Lukas bisa memberikan sedikit masukan ya. YouTube ya. Boleh yang susah pertanyaannya, saya nggak bisa jawab, Mas. So honestly I cannot answer that question because it's a comparative legal system between Indonesia and Singapore, and it is not my strongest suit in this case. If you talk about contract, I can answer that, but do you have any insight? Not yet. No. Beda expert. Ya. Gitu. Kalau kontrak saya jawab, Mas. Maaf ya, Mas Isan.
Nggak apa-apa, Bu.
Kesulitan pertanyaannya. Ya. Ada pertanyaan lain mungkin yang berhubungan dengan kontrak komersial internasional? Silakan. Ya, boleh, Mbak. Namanya? Tembang. Wow. Tembang means a song. So her name is very beautiful. Tembang merah, red song. Silakan, Mbak.
Sebelumnya terima kasih untuk kesempatannya. Saya ingin bertanya, semisal suatu kasus perdata itu berjalan di Eropa misalnya, terkait pengadilan perburuan dan lain sebagainya lah. Kemudian apakah ketika misalnya WNI yang telah bekerja di sana kemudian memiliki kasus seperti buru-buru lepas itu kalah dalam pengadilannya dan diharuskan membayar biaya perkara. Nah, apakah ketika mereka sudah berada di wilayah yurisdiksi Indonesia, kontrak pembayaran biaya perkara itu tetap berlaku gitu? Mereka tetap harus membayar biaya pengadilan tersebut? Atau mereka aman? Atau adakah seperti resiko apabila mereka tidak membayar biaya perkara dalam pengadilan? Terima kasih. WNI yang kerja di luar negeri, ya, seperti itu.
Workers who work in, for example, in the EU countries, and then they get a dispute related with the contract of employment, and then this foreign workers lost, and then they need to pay for the court administration fees. Or is there any such thing there in Europe? Dan terus nanyanya kalau nggak bisa bayar itu gimana gitu ya? Heeh. Dispute-nya di Eropa.
Yeah. About yeah, you can make it enforceable. Again, it depends on the. It will depend on the agreement, on the employment agreement. But if there was, for instance, under French law, if even if it's a wedding, Kajan in France, you have if it was working for a French company, the French labor law was applying. So if the decision, the judicial decision is made in grant him if they won in France, for sure the judgment cannot be enforced directly in Indonesia, but it can be enforced in France. So if the one if I was working in France and has the equivalent of a Kitas, he had to have a bank account and so on, he will be paid in France or he will be paid in Indonesia. So it's for this enforcement side from an Indonesian for Indonesian working in France, it will be easy. But then in the case where, for instance, this person is working for an Indonesian company but detached to France, if he has an employment agreement with the Indonesian company, you can enforce, you can do a litigation, dispute resolution in Indonesia based on the Indonesian labor law, and in France because he was detached in France. Yeah. No, not have that. No, but it's not. It's like labor law. Labor law is in France. It's really important and really protected. The employment relationship is really protected. But it's what I mean by that is the same in Indonesia. When I'm a foreigner, I have to abide by Indonesian labor law because I'm working here. So it's part of the. So it's the same with France for Indonesian. Sure. But this is.
What if one of the contents of an international agreement maybe have a conflicts with the country constitution? How is the conclusion? What is the strategy?
It will depend, but so maybe if you want to
Yes.
reply.
Constitution, what do you mean by constitution? Constitution itu maksudnya kayak undang-undang dasar atau undang-undang gitu. No. The Constitution.
So on this, there's a general principle is that public, because if it's constitution, by definition, it would be public order. And this is something you cannot, so even if you're doing arbitration and so on, for every law you choose, there will always be the public order, which will be above the law of the parties. So it's so it can happen. So this is something where in such a case, you really have to check on the law that will apply to the agreement, but basically, but the very difficult question behind it is how to define this public order, and this it depends on every country. So that's really complicated. Yeah.
Ketertiban umum ya. Jadi kan perjanjian bisa dibatalkan karena bertentangan dengan ketertiban umum gitu. Jadi konstitusinya itu dimaknai sebagai public order.
Thank you so much for your answer.
Thank you.
It so helped my mind.
Thank you.
Oh, waktunya. Oh, the time is up. Oh. Satu lagi boleh ya? One more question. Yes. See, they are very enthusiastic when it's almost end. You know, usually that's how the students do. Yes, it's normal for students. Go ahead.
Perkenalkan, saya Rema. Saya izin bertanya. Tantangan apa yang dihadapi oleh Pak Lukas selama berpraktik dalam pembuatan perjanjian internasional dan bagaimana cara penyelesaiannya? Terima kasih.
Thank you very much for the question. Terima kasih banyak untuk pertanyaan. No, so you have to, like personally, you just have to follow the rules. So basically, I don't do Indonesian law, but that's a challenge as well because I'm in Indonesia. So how do you do it? So you have a partner, and you work with him, and that's the most, because that's also that's the other thing we were talking about, immigration law, and not immigration, but foreign workers. In Indonesia, the rationale is that I'm here as well to transfer my knowledge. And it's a methodology. So my job is to be a methodological bridge between French companies or European companies and Indonesian legal practitioners. So that's, at my personal level, that's how I take it. That's how it's working, and that's how I'm in compliance with my position as a foreign lawyer and the regulation. After, at a more general level, of course, there are huge challenges in Indonesia concerning law. There is the compliance side. It's really, we have some pressure. It's, but there are efforts which are made by the government on it. I'm sorry to say this, but it's not enough yet. But at least they are tackling the issue. But it's true. It is at the end of the day, the end of our usefulness, for your utility. Sorry, because when you have some case of corruptions and so on, we are useless. We are useless. So these are the challenges, and there's no